Welcome back to Sovereign Judgment. Today's story is about what happens when an HOA mistakes a private bridge for community property, and a quiet landowner decides to stop asking them to read the deed. They had trucks, orange cones, reflective vests, and a president who liked to speak as if her letterhead carried the weight of law. I had a recorded plat, a county maintenance file, and a bridge my father built with his own hands in 1987. Before we begin, tell me where you're watching from in the comments. I always like seeing how far these stories travel. Here's what happened. The first sound was not the engine. It was the chain. Cold galvanized steel dragged across the gravel with a slow, scraping pull that seemed to carry across the whole valley. It was 6:42 on a Thursday morning, and the fog was still lying low in the creek bottom, wrapped around the sycamores and the old bridge rails like wet cotton. My boots were dark with dew. My hands smelled faintly of machine oil from the new lock. Across the bridge, 6 HOA trucks sat nose to tail on my side of the creek. White utility pickups, magnetic door signs, amber lights mounted on the roofs. 2 had flatbed trailers behind them, loaded with signs that read, in black block letters, Resident Access Project. Authorized personnel only. Behind them, 27 homeowners from Briar Glen Estates stood on the county road, trapped on the wrong side of their own arrogance. And in front of all of them stood HOA President Margaret Bellamy, wearing a cream-colored blazer and a hard yellow hat that still had the price sticker on the brim. She was holding up her phone, filming me. "You cannot close that bridge," she called out. I looked at the 2 sheriff's deputies standing beside the posted easement marker. I looked at the county engineer, who had his sealed folder tucked under one arm. Then I looked back at Margaret. "I already did," I said. The new steel gate settled into place with a soft metallic click, and for the first time in 9 months, Briar Glen Estates had no road in. To understand how a private bridge became the only thing standing between an HOA and the consequences of its own paperwork, you have to start with my father's survey notebook. My name is Daniel Mercer. I am a licensed civil engineer in the state of West Haven, and for 22 years I specialized in small bridge design, private road construction, drainage easements, and rural access disputes. Most of my work was ordinary: culverts that failed after spring storms, retaining walls built without permits, subdivision roads that developers promised to finish and then abandoned when the last lot sold. I learned early that land does not care what people believe about it. It only cares what was recorded. My family's land sat in Harlan County, West Haven, about 9 miles east of a town called Millstone Creek. Not the real county, not the real town, but that is close enough to understand the place. The property was 41.8 acres of mixed pasture, hardwood slope, and creek bottom. My grandfather bought the first 19 acres in 1954 for $3,200, back when that valley still had working hayfields and nobody used the word estate unless they were talking about probate. My father added the rest in 1979. He built the bridge 8 years later. It was a narrow steel and timber span crossing Laurel Fork, 74 feet from abutment to abutment, with poured concrete footings, weathered oak decking, and a posted 5-ton weight limit. He built it because our farmhouse sat on the west side of the creek, and the county road ended on the east side. Before that bridge, my mother parked near the mailbox and walked groceries across a plank footbridge when the water was low. Dad kept everything: receipts, concrete batch tickets, sketches, inspection notes. A stamped letter from the county road superintendent dated May 14, 1987, acknowledging that the bridge was private, privately funded, privately maintained, and not part of any public road system. That letter would become very important. When my parents died, 18 months apart, I moved back into the farmhouse. I was 51, divorced, and tired of hotel rooms near construction sites. The house still smelled like cedar closets and old coffee. My father's workbench still had pencil marks on the edge where he measured boards. From the kitchen window, I could see the bridge through the poplar trees, catching sunlight in the morning and frost in winter. For me, that bridge was not infrastructure. It was memory with steel under it. Briar Glen Estates arrived long after we did. The subdivision was built on 112 acres north of my property, on land that used to belong to the Taverner family. The developer, a man named Ellis Vaughan, marketed it as exclusive country living with private valley access. He sold 34 lots between 2004 and 2008. The houses were large, beige, and close together, with stone mailboxes and ornamental street lamps that looked expensive but rusted after 4 winters. There was supposed to be a proper entrance off County Route 18. That entrance existed on the recorded subdivision plat. It crossed a low ridge, curved around a stormwater pond, and connected to the state-maintained road near mile marker 11. The developer cleared the first 600 feet, installed a decorative sign, then stopped. Instead, during construction, his crews started using my bridge. At first, my father allowed limited temporary access under a written construction license. It was 3 pages, notarized, and very clear. The license allowed construction vehicles under 10,000 pounds to cross the bridge between June 1, 2005 and December 31, 2006. It did not create an easement. It did not transfer maintenance responsibility. It could not be assigned to homeowners, contractors, or any future association. My father put that in bold. When the housing market softened in 2008, Ellis Vaughan disappeared into bankruptcy. The proper entrance off Route 18 was never finished. Briar Glen residents kept using my bridge because it was convenient, and because my parents were kind people who did not want neighbors stranded. But kindness is not the same as surrender. After my father died, I let the arrangement continue temporarily while I sorted through the estate. I wrote letters to the HOA board twice a year, reminding them that use of the bridge was permissive, revocable, weight limited, and not permanent. I sent those letters by certified mail. I kept the green cards. Most residents were polite. A few even offered money for gravel or repairs. Then Margaret Bellamy became HOA president. Margaret first came to my door on September 12th, a Tuesday, at 8:17 in the morning. I remember the time because I wrote it down before I opened the door. She arrived in a silver Lincoln SUV, parked with 2 wheels on the grass, and walked up my porch steps holding a navy blue binder against her chest. She was in her late 50s, tall, narrow-shouldered, and immaculate in the way some people are when they mistake neatness for authority. Her hair was cut into a sharp white bob that did not move in the breeze. On her left lapel, she wore a small gold pin shaped like a key. Behind her stood a man named Victor Sloan, the HOA treasurer, carrying a rolled plan tube. "Mr. Mercer," she said, "I'm Margaret Bellamy, president of the Briar Glen Estates Homeowners Association." "I know who you are," I said. That was true. I had seen her name on 3 letters already. Each one had grown more formal and less accurate. She smiled without warmth. "We're here to discuss the access corridor." "There is no access corridor," I said. "There is my bridge and my driveway." Her smile stayed in place. "That is precisely the misunderstanding we need to correct." She opened the binder on my porch rail as if she were preparing to close on a loan. Inside were color-coded tabs, printed maps, photocopies of bylaws, and a document with the Briar Glen seal at the top. She tapped one page with a manicured fingernail. "The HOA has determined that the bridge and lower road are part of Briar Glen's historic ingress and egress route. We are beginning an improvement project next month. Shoulder widening, guardrail replacement, resurfacing, signage, and controlled access management. On my property," I said. "On the community access route," she corrected. I looked past her toward the bridge. A delivery van from a cabinet company was crossing it too fast, boards humming under its tires. "What recorded instrument gives Briar Glen the right to improve or control that bridge?" I asked. Margaret turned one page, then another. "The right is established through long-standing use. That is not an instrument. It is a legal doctrine." "Which one?" She paused for half a second. "Prescriptive continuity," she said. Victor Sloan looked down at his shoes. "There is no such doctrine in West Haven property law. There is prescriptive easement, there is adverse use, there is implied dedication under very specific circumstances. But prescriptive continuity was a phrase that sounded legal because someone had placed 2 legal adjacent words next to each other and hoped nobody would ask a second question. I did ask. "Who gave you that opinion?" Margaret closed the binder. "Our counsel has reviewed the matter." "Name?" "That is not necessary at this stage. It is if you intend to bring crews onto my land." Her expression tightened. The porch light was off, but I could see the brass fixture reflected in her sunglasses. "Mr. Mercer, this community has relied on that bridge for nearly 20 years. You cannot suddenly decide to hold 34 families hostage because you dislike progress." I nodded once. "I'm not holding anyone hostage. I'm asking you not to trespass." She leaned closer. "You should be careful with that word." I looked at Victor again. He still would not meet my eyes. Margaret handed me a notice printed on thick paper. It said the HOA would begin authorized maintenance and access normalization work on October 3. It also stated that any obstruction of the bridge, roadway, or community access corridor would result in fines of $500 per day under Article 9, Section 12 of the Briar Glen Estates governing documents. I took the notice. "Do you have a copy of Article 9, Section 12? I asked. "It is in the packet." I opened the packet while she stood there. The bylaws ended at Article Fee. Margaret's face did not change, but one hand closed around the binder rings. "I'm sure you understand the point," she said. "I understand more than the point." After they left, I stood on the porch and watched the Lincoln cross my father's bridge. The oak deck flexed under the weight, exactly as it was designed to do. But I noticed something I had not seen before. The west railing had shifted outward by nearly an inch. That afternoon, I began the file. Not a folder, a file. I had spent my career watching disputes turn on the smallest piece of paper. People assume ownership is obvious because a road looks like a road, or because a bridge has always been there. But land records are not based on habit. They are based on descriptions, grants, plats, dedications, easements, licenses, maintenance logs, tax maps, and signatures. So I started at the Harlan County Recorder's office. The public terminal was an old gray machine near the back wall, between a cabinet of marriage books and a bulletin board full of zoning notices. The clerk on duty, Naomi Kessler, remembered my father. She had worked there since 1981 and still used a date stamp with blue ink. "You looking for the bridge file?" she asked. "I think so." She nodded toward the terminal. "Your dad was particular. It'll be there." I pulled every recorded document tied to my parcel. Parcel 14-07-31-002A, the 1954 deed, the 1979 warranty deed, the 1987 construction acknowledgement, the 2005 temporary construction license, the 2007 termination letter my father sent to Ellis Vaughan when trucks began exceeding the weight limit. Then I pulled Briar Glen's documents. The original subdivision plat was recorded March 3, 2004. Plat Cabinet D, Slide 219. It showed a 50-foot private road easement connecting all Briar Glen lots to County Route 18. That easement did not touch my land. It ran entirely through the subdivision's common area. The HOA declaration, recorded the same day, listed all common roads maintained by the association. Laurel Fork Bridge was not included. My lower driveway was not included. Parcel 14-07-31-002A was not mentioned anywhere. Then I found the first flaw. A 2006 amendment to the declaration referenced temporary construction access across the Mercer Bridge under separate license agreement. The phrase temporary construction access was underlined in the scanned copy because someone had marked it with pen before recording. 2 paragraphs later, it stated that permanent residential access would be provided through the Briar Glen North entrance upon completion. The north entrance was the unfinished road off County Route 18. I paid $38.50 for certified copies. Then I checked the Harlan County Assessor database. Briar Glen's common area parcel, number 14-07-12-1118, C, still included the dedicated roadbed for the north entrance. The HOA owned it. They had owned it for 19 years. Their tax assessment even classified 2.6 acres as private road reserve. They had a road. They had simply never built it. The next search was with the West Haven Secretary of State. Briar Glen Estates HOA was active, but its registered agent had changed 4 times in 6 years. The current agent was listed as Bellamy Residential Management, LLC, Margaret's company. The company had been formed 11 months before she became HOA president. I printed that too. Then I searched the West Haven Bar Association for the attorney whose name appeared on the HOA's earlier letters, Caldwell and Pike Legal Group. No such firm existed in the state directory. A deeper search showed that Stephen Pike, the person signing the letters, had surrendered his law license in 2019 after a disciplinary proceeding involving trust account irregularities. He was not disbarred in the dramatic way people imagine. He was simply not authorized to practice law. Yet his signature appeared beneath 3 letters threatening immediate civil enforcement action against me. I did not call Margaret. I did not post online. I did not warn the neighborhood. I made a timeline. September 12th, 8:17 a.m. Margaret Bellamy delivered notice of unauthorized bridge project. September 12th, 2:40 p.m. Certified copies obtained from Harlan County Recorder. September 12th, 4:05 p.m. Secretary of State record confirms Bellamy Residential Management LLC, registered agent relationship. September 12th, 5:22 p.m. Bar Association search confirms Stephen Pike inactive since 2019. Then I walked the bridge. I carried a flashlight, a level, a probe rod, and my father's original inspection sketch. Under the east abutment, the creek smelled of wet stone and leaf mold. The underside beams were still sound, but the timber deck had 3 compromised planks near the center line. The railing shift was real. The west approach had rutting from overweight vehicles. My bridge was being used as a subdivision road, a construction route, and now, apparently, a staging area for an HOA project nobody had the right to perform. I photographed everything with a scale ruler in frame. By then, the outcome was not emotional to me. It was procedural. Margaret escalated 6 days later. On September 18th, a bright orange notice appeared stapled to the cedar post beside my mailbox. Notice of community access violation. It claimed I had interfered with HOA-managed ingress by parking my tractor near the bridge approach. The tractor was on my gravel apron, 18 feet from the travel lane, and had been there for 2 days because I was replacing a hydraulic hose. The fine was $500. By September 22nd, the fine had become $2,500. By September 29, I had received a letter from Stephen Pike demanding that I cease and desist from obstructionist conduct and warning that the HOA would seek emergency injunctive relief, punitive damages, and lien rights against the Mercer property. Lien rights. Against land that was not in their association. That was the kind of phrase that made people panic. It was meant to. It sounded heavy. It sounded official. It sounded expensive. I logged the envelope, scanned the letter, and put the original in a plastic sleeve. Then the neighborhood posts began. Briar Glen had a private online group called Briar Glen Residents Forum. I was not a member, but one of the residents, a retired school librarian named Evelyn Hart, printed screenshots and brought them to my house in a manila envelope. Evelyn lived at 22 Juniper Row. She was 73, widowed, and had moved into Briar Glen because the brochure promised maintenance-free rural living. Her husband's oxygen supplier used my bridge twice a month during his final illness. She had never known the bridge was private until Margaret started telling residents that I was trying to extort road fees from elderly homeowners. Evelyn stood in my kitchen with both hands around a mug of tea. She told us you were demanding $190,000, she said. I have demanded nothing. I thought so. The screenshots showed Margaret writing long posts about protecting resident access from a hostile adjoining landowner. She claimed I had inherited a forgotten farm crossing and was now attempting to commercialize a community route. She posted a cropped image of the 2005 temporary license, carefully excluding the expiration date and the clause stating that no easement was created. That mattered, not because it hurt my feelings, because it showed intent. On October 3rd, at 7:04 a.m., the first HOA truck arrived. It was a white pickup from Bellamy Residential Management LLC, not from the HOA. 2 men in reflective vests got out and placed orange cones on my bridge. A third man began unloading metal signposts from the flatbed. I walked down from the house with my phone already recording in my shirt pocket. "Morning," I said. One of the men looked uncomfortable. "Ma'am said we're supposed to start staging here." "Who is ma'am?" "Mrs. Bellamy. You are standing on private property. You do not have permission to stage, work, park, install signs, or restrict access." He looked at the cones. "She said it was Association Road." "It is not." I handed him a one-page notice I had prepared the night before. It included the parcel number, deed reference, temporary license expiration, and my contact information. It stated clearly that any further entry for construction purposes would be treated as trespass and documented. He read it. Then he did something Margaret never did. He left. At 8:31, Margaret called my phone. I did not answer. I wanted everything in writing. At 8:47, she emailed, "Your interference this morning has been forwarded to council. The HOA will not be intimidated by selective documents or amateur interpretations." I saved the email as a PDF. At 9:15, she posted again in the residents group, claiming I had blocked emergency access. Evelyn sent the screenshot at 9:22. Emergency access was the next word they tried to weaponize. On October 6th, I received a letter on Briar Glen letterhead stating that the HOA had authority to enter my property under public safety necessity. There was no citation, no statute, no order from any agency, just the phrase, typed in bold. That afternoon, I called Harlan County Fire Marshal Thomas Reed. I did not ask him to take my side. I asked for records. He confirmed that Briar Glen's emergency access plan filed in 2004 listed the north entrance off County Route 18 as the primary route and my bridge as temporary construction access only. He also confirmed that no public agency had ever designated my bridge as an emergency road. Then he said something quietly. "We've been telling them for years they need to finish that north road." How many years? Since 2011, at least. He emailed me copies of 3 inspection notes. In 2014, the HOA was advised to improve the north entrance. In 2018, the HOA was warned that relying on a private bridge was not acceptable for long-term emergency planning. In 2021, Margaret Bellamy herself signed an acknowledgement that the HOA was responsible for maintaining its recorded access easement. That signature would become the hinge. I retained attorney Lydia Chen on October 9th. Lydia specialized in rural property disputes, HOA boundary issues, and access litigation. Her office was above an old bank in downtown Millstone Creek. The conference room had thick glass windows, and when she set my evidence binder on the table, it landed with the dull weight of something that had stopped being a disagreement. She read for 42 minutes without speaking. Then she looked up. "You have been more patient than most courts require." "I don't want to fight," I said. "No," she said. "You want a record?" I nodded. She took out a yellow legal pad. "We need 4 things before you make any physical change. First, a title opinion. Second, a survey update. Third, a bridge safety assessment. Fourth, written notice with a cure period. I can close it?" She did not answer immediately. She turned back to the 1987 county letter, the 2005 temporary license, and the 2021 fire marshal acknowledgement. If the bridge is private, and no recorded easement exists, and the current use is permissive only, then yes, you may revoke permission. But you need to do it cleanly. No surprise. No self-help that creates a safety issue. No blocking emergency vehicles. No confrontation. You give them written notice. You give them time to use their own recorded access. You document every warning. How much time? 30 days is reasonable. 60 is safer. I chose 60. Not because Margaret deserved it, because a judge would notice. On October 11th, Lydia sent a certified letter to Briar Glen Estates, HOA, Margaret Bellamy, Bellamy Residential Management LLC, and every homeowner of record in the subdivision. The letter was 7 pages. It stated that the Mercer Bridge and Lower Road were private property, located entirely within parcel 14-07-31-002A. It attached the deed references, plat excerpts, county acknowledgement, and temporary license. It revoked all permissive use, effective December 15th, at 12:01 a.m., except for emergency services, utility repair by written coordination, and individual residents who requested temporary accommodation for documented hardship during the transition period. It also advised the HOA to open its recorded north entrance from County Route 18. The next day, Margaret called a special HOA meeting and told residents the letter was a bluff. Evelyn sent me audio. I did not ask her to record it. She had done it because Margaret had begun blaming her for feeding information to the farm man, as if accuracy were a form of disloyalty. On the recording, Margaret's voice was smooth and confident. "Mr. Mercer has no practical ability to close that bridge. It is our established entrance. Our legal position is strong. I have directed our management company to proceed with the improvement plan." Her management company. That was the first time she said it publicly. On October 16th, Lydia ordered a title report from Hartwell Abstract Services. It came back clean. No easement, no dedication, no maintenance agreement, no access covenant, no prescriptive claim filed by any party. On October 21st, licensed surveyor Miles Abernathy came to the property with 2 assistants and a robotic total station. They worked for 6 hours, setting flagged stakes along the property line and the bridge approaches. Miles was a careful man, with a gray beard and a habit of saying measurements aloud before writing them down. The final survey showed exactly what my father's documents had shown. The bridge, the west approach, the east apron, and 312 feet of lower gravel road were entirely inside my parcel. On October 24th, structural engineer Priya Nandakumar inspected the bridge. Her sealed report found that the structure was safe for light residential use, under 5 tons, but had sustained accelerated wear from repeated overweight vehicles. She recommended immediate restriction against contractor trucks, utility trailers, and loaded flatbeds until deck repairs were completed. That report changed the tone of the matter. Now, this was not only property, it was liability. On October 28th, Lydia sent a second notice. This one included the structural report and prohibited all vehicles over 5 tons effective immediately. The notice stated that repeated overweight crossings would be recorded and referred for civil damages. The next morning, Bellamy Residential Management sent 3 trucks across the bridge carrying gravel, signposts, and temporary barricades. All 3 were over 5 tons. My cameras caught each truck from 2 angles. I had installed the cameras legally on my own property, pointed only at the bridge and road, each one uploaded to cloud storage. Each clip had a timestamp and watermark. The first truck crossed at 7:13 a.m., the second at 7:19, the third at 7:31. At 7:36, one of the men placed a sign on my side of the bridge. Briar Glen, resident access only. I let the sign stand for 18 minutes. Then I photographed it, measured its distance from the property line, removed it, and placed it in my barn. I emailed Margaret one sentence. "Your sign has been removed from my property and preserved as evidence." She replied 9 minutes later, "You are making this much worse for yourself." That sentence became Exhibit 17. By November, the dispute had moved beyond paper. Residents began stopping at my gate. Some were angry, some were frightened. Most had simply been misled. A man named Cole Whitaker, who lived on Briar Glen Court, told me Margaret had said their homes would become landlocked unless they approved a $2,800 special assessment per household to fund legal action against me. I asked him one question. "Has she shown you the recorded north entrance?" He looked confused. "The what?" I printed a copy of the subdivision plat and highlighted the easement. He stared at it in silence. "You mean we own another way out?" "The HOA does. That road is just trees." "Yes, but it's ours." "Yes." By the end of that week, 7 residents had requested copies. Margaret responded by sending another letter. This one claimed I was communicating false legal theories to association members and interfering with governance. It demanded that I cease all contact with Briar Glen residents. I was not a member of her HOA. Her authority over me was exactly 0. Still, I did not respond publicly. I forwarded the letter to Lydia. Lydia replied with 3 words. "Helpful. Keep it." The setup took most of November. I applied for a private access gate permit from Harlan County Planning on November 6th. Because the gate would be on private land and outside any public right-of-way, the permit was administrative. The county required setback measurements, emergency access provisions, reflective marking, and a NOx-compatible emergency lockbox for fire and EMS. I provided all of it. I also applied for a bridge deck repair permit and a temporary closure authorization for private infrastructure maintenance. The authorization did not give me ownership. I already had that. It documented that the closure had a safety basis and that the county had reviewed the emergency access plan. Fire Marshal Reed approved the emergency lockbox on November 18th. The sheriff's office acknowledged receipt of the closure notice on November 20. On November 22nd, Lydia sent the third and final notice. The bridge would close to Briar Glen residential traffic on December 15 at 12:01 a.m. Emergency vehicles would retain access. No HOA vehicles, management company vehicles, contractors, residents, guests, delivery services, or unauthorized third parties would be permitted to cross after that time. The letter included a map of the HOA's recorded north entrance, a copy of the 2021 acknowledgement Margaret had signed, and the county engineer's statement that the HOA-owned access route was outside my property and could be opened by the association. Margaret's response was not legal. It was theatrical. On December 1st, she announced a Resident Access Preservation Project. She sent a glossy email with a project logo, a schedule, and a photograph of my bridge taken from the road. She said the HOA would be formalizing control over the route on December 12th, 3 days before my closure deadline. She hired trucks. She hired workers. She ordered signs. And then she put the whole thing in writing. At 6:18 a.m. on December 12th, the first HOA truck parked across my private bridge. By 6:44, there were 6 of them. They were lined up bumper to bumper across the span and both approaches, blocking the bridge completely, not improving it, not crossing it, blocking it. I watched from the kitchen window while coffee steamed untouched beside my hand. The morning was cold enough that exhaust hung in layers above the creek. Men in vests stood near the trucks, stamping their feet. One carried a clipboard. Another placed cones across the east approach. Margaret arrived at 7:02 in her silver Lincoln, wearing the same white bob, the same key pin, and the same expression she had worn on my porch. I called Lydia. Then I called the sheriff's non-emergency line. Then I walked down to the bridge. My phone was recording. The cameras were recording. The deputy's body cameras would soon be recording. Margaret saw me coming and lifted her chin. "Mr. Mercer," she said, "as you can see, the association has taken possession of the access route, pending legal clarification." "That is not possession," I said. "That is trespass." She gave a small laugh for the benefit of the men around her. "You keep using that word as if saying it makes it true." I handed her a printed copy of the final notice. She did not take it. "You were warned in writing on October 11th, October 28th, and November 22, I said. "Your permission to use this bridge terminates in 3 days. Your vehicles are over the posted limit and are blocking private infrastructure." She turned toward the crew. "Continue staging." Nobody moved. The first deputy arrived at 7:19. His name was Deputy Aaron Vale. He was young, polite, and visibly unhappy to be standing between a private landowner and 34 households. 10 minutes later, Sergeant Marla Dinn arrived. She had read Lydia's notice because it had been copied to the sheriff's office. Margaret launched into her speech before the sergeant finished stepping out of her vehicle. "This man is attempting to unlawfully cut off access to an entire residential community," she said. "We have established rights through continuous use, emergency necessity, and HOA governance authority." Sergeant Dinn looked at me. "Mr. Mercer?" I handed her the evidence packet I had prepared for that exact moment. 1 folder. 12 tabs. No argument. She read the cover sheet, then the county letter, then the survey excerpt. The creek moved under the bridge with a thin winter sound. Finally, she looked at Margaret. "Ma'am, do you have a court order?" Margaret blinked. "We don't need a court order to maintain our own access route. Do you have a recorded easement? Our council has addressed that. Do you have it with you?" Margaret looked toward Victor Sloan, who had arrived in a fleece vest and loafers. He did not speak. Sergeant Dinn said, "These vehicles need to move." Margaret's voice sharpened. "If you assist him in blocking our community, the county will be liable." The sergeant's expression did not change. "No, ma'am. I'm telling you not to block a private bridge." It took 43 minutes for the trucks to clear. Every minute was recorded. At 8:28, the last Bellamy residential management pickup crossed east and stopped on the county road. Margaret stood near the mailbox, speaking urgently into her phone. I did not close the bridge that day. I waited. The deadline was December 15th. At 12:01 a.m. on December 15th, I revoked the access, as noticed. At 6 a.m., I met the gate contractor at the east approach. The company was Millstone Ironworks. The owner, Grant Ivers, had installed ranch gates, utility barriers, and private road systems for 30 years. His crew brought a matte black steel swing gate, 2 concrete set bollards, reflective markers, a keypad for authorized emergency access, and the Knox lockbox approved by Fire Marshal Reed. The air smelled like diesel, cold mud, and fresh-cut steel. At 6:42, I pulled the chain across the gravel while Grant checked the hinge alignment. By 7:05, the gate was locked. At 7:16, the first Briar Glen resident arrived and stopped 20 feet short of it. Then another, then 4 more. By 7:40, a line of vehicles stretched along the county road. Residents trying to enter, delivery vans, a landscaping trailer, and 2 Bellamy residential management trucks. The trucks had arrived first, trying to beat the closure. They were now parked on the public side of the gate, unable to cross. Margaret arrived at 7:51. She got out of the Lincoln with her phone already raised. "You cannot close the only road in," she said. I was standing beside the posted sign. "Private bridge. No HOA access. Emergency services authorized. Parcel 14-07 31 002A. Closure notice served. October 11th, October 28th, November 22. "It is not the only road in," I said. "For practical purposes, it is. That is a Briar Glen problem. You'll be sued by lunch. That is your right." She walked close enough that Deputy Vale, who had returned with Sergeant Dinn, stepped slightly forward. "You are endangering families." "No," I said. "I am closing private infrastructure after 64 days' notice. Your recorded entrance is 1.3 miles north." A man in the line of cars shouted, "Margaret, where is the north entrance?" She ignored him. The county engineer, Samuel Ortiz, arrived at 8:12 with a rolled plan set and a fluorescent vest. He had inspected the records the day before. He placed the Briar Glen subdivision plat on the hood of his county truck and pointed to the road reserve. "The HOA-owned access easement begins here," he said to the residents who had gathered. "It connects to County Route 18. It was approved as the permanent entrance in 2004. Margaret said, "That entrance was never completed." Ortiz looked at her. "Correct. Then they can't use it." "They can, if the HOA builds the road it was required to build." That was the moment the crowd changed. Not loudly, not dramatically, but the energy shifted from fear toward calculation. People began looking at Margaret instead of me. Cole Whitaker stepped forward. "How much have we paid for road maintenance?" Margaret's mouth tightened. "This is not the forum." Evelyn Hart, small and steady in a brown wool coat, said, "It is now." The gate stayed closed. The sheriff's office confirmed on site that I was within my rights. Fire Marshal Reed tested the emergency lockbox at 9:05 and opened the gate for a simulated emergency access check, then relocked it. The test was logged. The deputies left at 9:40. Margaret stayed until almost 10, pacing beside her Lincoln, making calls that did not open the bridge. By noon, Briar Glen residents were hiking through their own unfinished north entrance with phones in hand, filming the overgrown roadbed their HOA had owned all along. By sunset, someone had created a new residence group without Margaret in it. But Margaret still had one move left. She called a public emergency meeting for December 18th at the Briar Glen clubhouse. Lydia advised me not to attend alone, so I did not. I attended with her, with a court reporter, and with a complete evidence binder. Evelyn Hart, Cole Whitaker, and 29 other homeowners attended. So did Margaret, Victor Sloan, and Stephen Pike, the inactive attorney, who appeared on a video call wearing a dark suit and speaking from a room with fake law books behind him. The clubhouse smelled like burnt coffee and floor wax. Margaret stood at the front beneath a framed copy of the Briar Glen mission statement. Her white bob was perfect. Her gold keypin caught the overhead light. She began with confidence. "For months, Mr. Mercer has engaged in a calculated campaign to deprive this association of its lawful access. He has misled residents, harassed vendors, and now installed an unlawful gate across a community route. Tonight, we will vote to authorize full litigation and emergency removal." She clicked to the first slide. It showed a map. My bridge was marked in red. The HOA's north entrance was not shown. Lydia leaned toward me and whispered, "Let her finish." Margaret spoke for 18 minutes. She cited continuous use. She cited safety. She cited prescriptive continuity again. She cited the temporary construction license but described it as an access agreement. She claimed the HOA had invested $86,400 in bridge-related planning. Then she made the mistake that ended her. She displayed an invoice from Bellamy Residential Management, LLC, for Access Preservation Project Management. The amount was $18,750. The client was Briar Glen Estates HOA. The authorizing signature was Margaret Bellamy. The date was October 1, 2 days before her company first attempted to stage trucks on my property. Cole Whitaker stood up. "Is that your company?" Margaret looked irritated. "It is the association's contracted management provider." That wasn't the question. Victor Sloan leaned toward his microphone. Margaret disclosed the relationship. Evelyn Hart lifted a folder. "Not in the minutes." The room went still. Lydia stood then. Not dramatically, just enough that the court reporter turned toward her. "My name is Lydia Chen. I represent Daniel Mercer. Before this board votes on litigation, I have one question." Margaret folded her arms. "Proceed." Lydia held up the 2021 Fire Marshal acknowledgement. "Mrs. Bellamy, is this your signature?" Margaret looked at the document from 10 feet away. "I would need to review it." Lydia placed copies on the front table. "It is the Harlan County Fire Marshal's 2021 Access Compliance Acknowledgement. In it, you confirmed that Briar Glen Estates HOA was responsible for completing and maintaining the north entrance as the permanent emergency and residential access route. Is that your signature?" Margaret's face changed by a fraction. Stephen Pike's video square froze for a second, then resumed. "This is an ambush," Margaret said. "No," Lydia said. "This is your document." Then Lydia played the October 12 HOA meeting audio, the one Evelyn had recorded in a one-party consent state. Margaret's voice filled the clubhouse. "Mr. Mercer has no practical ability to close that bridge. It is our established entrance. Our legal position is strong. I have directed our management company to proceed with the improvement plan." Lydia stopped the recording. "Your management company billed the HOA for work on private property after Mr. Mercer's counsel notified you that no easement existed. You then showed residents a cropped version of an expired temporary license, omitted the recorded north entrance, and requested authority to spend association funds on litigation over a route you personally acknowledged in 2021 was not the permanent access." Nobody spoke. Then Samuel Ortiz, the county engineer, stepped forward from the back of the room. He had not come with me. He had come because residents asked him to explain the plat. He unrolled the 2004 subdivision plan on the table. "The recorded permanent entrance is here," he said. "The county has no record accepting the Mercer Bridge as public or association infrastructure. Any representation otherwise is not supported by our files." Margaret looked at the room then, and for the first time since I had met her, she seemed to understand that titles only work when people keep believing in them. The vote did not authorize litigation. It removed her, 29-3, with 2 abstentions. Victor Sloan resigned before the meeting ended. Stephen Pike disconnected without saying goodbye. The legal resolution took longer because real consequences usually move slower than public embarrassment. On January 9th, the new interim HOA board sent me a formal apology, signed by Evelyn Hart as acting president. They acknowledged that Briar Glen had no recorded right to use the bridge. They agreed to stop all claims of access, remove all references to the Mercer Bridge from association materials, and begin engineering work on the north entrance. On January 22nd, Lydia filed a civil complaint against Bellamy Residential Management, LLC, Margaret Bellamy individually, and Briar Glen Estates HOA for trespass, nuisance, slander of title, and declaratory judgment. The HOA's new board settled quickly. Their insurer paid $41,600 toward my bridge deck repairs, legal fees related to the access dispute, and survey costs. In exchange, I released the association, not Margaret and not her company. Margaret fought. That was her choice. Discovery was not kind to her. Bank records showed Bellamy Residential Management had billed the HOA $63,240 over 14 months for access consulting, legal coordination, vendor staging, and resident communications related to the bridge. The board had never approved a competitive management contract. Meeting minutes had been altered after the fact. 3 invoices referenced work performed by Stephen Pike as legal strategy review, even though he was not licensed to practice law. The West Haven Attorney Regulation Office issued a cease and desist order against Pike on February 11th for unauthorized practice of law. The Harlan County District Attorney charged Margaret on March 3rd with 2 counts of misdemeanor fraudulent business practices and 1 count of falsifying association records. The charges were not dramatic television charges. They were paperwork charges. But paperwork had been her weapon, and paperwork was what finally answered. On April 18th, the civil case resolved by consent judgment, Margaret Bellamy and Bellamy Residential Management LLC agreed to pay $118,400 in damages, attorney's fees, and repair costs. The judgment permanently barred them from representing any right, title, easement, license, or authority over my bridge, driveway, or lower road. Margaret also agreed not to serve as an officer, director, manager, or paid contractor for any homeowners association in West Haven for 7 years. Briar Glen's new board assessed each homeowner $1,950 to complete the north entrance. That sounds like a loss for the residents, but it was less than the $2,800 Margaret had tried to collect for litigation she could not win. More importantly, it bought them something real: their own road. Construction began in May. By August, Briar Glen had a proper paved entrance off County Route 18, with drainage ditches, a culvert, streetlights, and a county-approved emergency access plan. The first time I drove past it, I saw Evelyn Hart standing near the new stop sign, watching the asphalt roller finish the shoulder. She raised one hand. I raised mine back. We never became close friends, but there are some people you respect because they choose the truth when it becomes inconvenient. That fall, I repaired the bridge. I replaced the damaged deck planks with white oak. I reinforced the west railing. I resurfaced the approach and installed a small bronze plaque on the inside of the gate where only someone crossing lawfully would see it. Mercer Bridge, built by Thomas Mercer, 1987. Private land, private labor, private right. The morning after the work was finished, I walked down before sunrise. The creek was low, moving over flat stones in the blue-gray light. The air smelled like wet leaves and new timber. For the first time in years, there were no tire tracks that did not belong to me. No cones, no signs, no trucks with magnetic logos pretending that a printed emblem could replace a recorded deed. I stood in the center of the bridge and rested one hand on the railing my father had designed. It felt solid, not new, solid. There is a difference. Justice did not look like revenge. It looked like a gate with emergency access. It looked like an HOA forced to build the road it should have built 19 years earlier. It looked like residents finally seeing the documents their board had hidden from them. It looked like a private bridge returning to what it had always been, a way home. There are 4 lessons I took from what happened. If someone claims a right over your land, ask for the recorded instrument. Not a story, not a tradition, not a phrase that sounds legal. A deed, easement, plat, license, or court order. Temporary permission should always be written, dated, limited, and preserved. My father's 2005 construction license saved me because it said exactly what it was and exactly what it was not. Do not interrupt an overconfident person while they are creating evidence. Margaret's posts, invoices, letters, meeting statements, and cropped documents did more damage to her than anything I could have said. Before you make a decisive move, make it boringly legal. Notices served, permits approved, emergency access protected, surveys certified, reports sealed. When the gate closed, the argument was already over. I still unlock the bridge sometimes for fire inspections, utility coordination, or a neighbor with a legitimate need who asks the right way. But nobody crosses it because they assume they can. Not anymore. If you have thoughts on this story, or if you have ever seen an HOA confuse convenience with ownership, share it in the comments. And if you want more stories where the documents speak louder than the bullies, like this video, and subscribe to Sovereign Judgment. The bridge is quiet now. That is how I know it is mine again.